Hello, my name is Paul England and I'm the Senior Counsel Knowledge in the Patents and Innovation Group at Taylor Wessing. This is where I'm the lead author of a practitioner's guide to the Unified Patent Court, a Hart Bloomsbury practitioner's text, which is coming out in its second edition on the 1st of May this year. The Unified Patent Court, the UPC, opened its doors for business on the 1st of June 2023, of course, a date which also marked the start of the unitary patent. So after more than 22 months of operation, how have the most important aspects of its procedure developed in that time? Well, this 1-hour webinar is intended to cover those features of the UPC procedure that are key to the passage of a dispute through to oral hearing and appeal, and which have been the particular focus of cases since the court opened. To be more precise, what I want to do in this webinar is focus on the following topics, which are the more substantial and important procedurally. Issues of service in the UPC and how these have been resolved. The so-called front-loaded nature of pleadings in the UPC proceedings, and the question of what can be added to pleadings or how they can be amended after service, and how late on. Confidentiality protection as between the parties to the UPC patent dispute and the circumstances in which pleadings can be obtained by the public. The rules relating to disclosure of documents and the communication of information, and what we know so far about appeal procedures. Let's begin with service. The service of statements of claim, orders, decisions, and pleadings is carried out by the sub-registry of the division of the UPC where the action has been lodged. But it's a statement of claim where this is most important. The primary method of service of the statement of claim, which fires the gun on an infringement action, is the electronic service. According to this method, the infringement statement of claim must be served by the registry at an electronic address provided for this purpose by the defendant, or alternatively on a representative of the defendant if the defendant has provided one. This is in Rule 271 of the Rules of Procedure. When doing this, the sub-registry has to advise the defendant of the right to refuse to accept a statement of claim if it's not written or not accompanied by a translation into a language that the defendant understands or which is an official language of the place where service is to be effected.